Okay, so this is LAWS 12066 Land Law. Now, the topic we're doing tonight is leases, which is topic 7. But as foreshadowed, we're going to be spending 2 weeks on this substantial and important. Can I say that again? Important topic. I should say it 3 times. Important topic of leases, right? And it's a big topic, big in a chunk of the casebook, 150 pages. My goodness. And I know what some folks are going to say in the evaluations. Michael, why are you overwhelming us with this unbelievable reading load? It's just overwhelming. But this is a big topic, and that's why we're spending 2 weeks on it. And I think how I've chunked it up is right in terms of doing. Tonight we're focusing on creating leases, the different types of leases that can be recognisable in law, and then very importantly these covenants, which essentially, what's a covenant? I mean, a covenant is a special term, for want of a better expression, inside the lease that is about the rights and obligations of the parties to the lease, the lessor and the lessee. And that's really, these are important things because that's basically what both sides are obligated to undertake or have rights with respect to. And if things aren't being attended to, then whose responsibility is that? And who has to pay for that, right? Now, the other thing that we need to just bear in mind, and I've pointed this out elsewhere in the lectures and so on, that what we're looking at mostly in this topic that we're covering in this unit in land law is what I could refer to, it's the general law of leases, okay? And that means that it's governed by property law legislation, which means the Property Law Act, there's Osmond. Our numbers are expanding exponentially. We're up to 6 or 7. Oh, right, up to 7. That's great. General law of leases, and so that's the legislation. The Property Law Act, very important, PLA. Land Title Act also becomes important with regard to the fact that we're mostly obviously talking about Torrens title, and so the issue around leases being able to be registered on the Torrens register, and so on, and what protections that gives, and so on. And we've seen already that that's a type of interest that can be registered on the title and encumber the title of the registered proprietor, just like a mortgage can. So Land Title Act relevant, Property Law Act relevant, and then broad body of case law, which articulates out the principles of leases with regard to very often the rights and responsibilities and also how we recognise a lease and so on, whatever. This topic touches on a couple of other frameworks of law that are specific legislation with regard to specific types of lease situations, namely the retail shop lease situation under the Retail Shop Leases legislation Queensland, which was amended in 2016, and also residential tenancy situation, which is governed by the Residential Tenancies and Rooming Accommodation Act 2008 Queensland. We're not going into those in any detail. One of the questions tonight actually just highlights the potential relevance of the RSLA and how it might pop up or come up in a sort of like commercial type situation that's involving a retail shop. But the bulk of our discussion focuses on this general law lease framework, if you like, and the type of situation that relates to is a commercial lease. That is where we have commercial land premises which are being leased for the purposes of generating income for the owner. Okay, so, and where the property is leased, or where the premises are leased, that's been, you know, the lessee is coming in to run a business, most typically, to do something that's usually in the nature of a business. And other situations, that's true with regard to retail shops as well, of course. Residential tenancies, different scenario. That's about people living and dwelling in premises, and that's dealt with under separate legislation. So what we're talking about here is the law that's primarily governing commercial leases, that is about someone or an entity that owns land, owns freehold, and it's commercial building or industrial land or whatever, and it is being leased for the purposes of generating income for the landlord, for the owner of the premises. Okay. But interestingly, as I point out in my lectures, that the actual that feature of gaining revenue or rent is not actually a fundamental characteristic of defining a lease relationship. That might surprise you. You might think, seriously? Surely that's got to be the main reason it's happening. It is the main reason, but it's not, from the law's perspective, fundamental characteristic of a lease in terms of whether we have a lease as opposed to a license or nothing, even though it's called, might be called a lease, but if it's not actually a lease according to law, then that's not what we have. And then there are certain characteristics of that. And those fundamental characteristics are about exclusive possession and about certainty of term from the arrangement that's been entered into between the parties. The other point, just before we get on to the questions, is to appreciate that in a commercial situation, the bargaining power between the lessor and the lessee is far more equivalent than it is, for example, in a residential tenancy situation. And you must remember that when a lessee is coming in to lease commercial premises to run a business, right, unless the nature of their business, I mean, say for example, if we, and most typically that's what lawyers do, they don't buy premises, they lease premises, right? If you're running a professional practice, then, you know, there's not too many changes that you need to do to premises usually if they've been run, you know, been operating a similar type of service business previously. You might want to, you know, do things, partitions and these sorts of things, and but you can imagine all different types of businesses, cafes, restaurants, bakeries, patisseries, things that require you to make things or to cook things or to serve up produce or food. If you're coming in as a potential lessee, you may well need to make significant changes to these premises to allow you to run your business. So one of the questions that arises initially as a practical consideration is the lessor has to ask themselves, well, do they want this sort of business to come into these premises? That's the first point. Second point is when they start the negotiation around the lease, they then have to talk about, well, who's going to do what? Who's going to take responsibility for making the changes to the premises to accommodate the business of the incoming lessee? Now, from a perspective of a property lawyer dealing with this, property lawyers deal a lot with commercial leases, right? We don't really have very much involvement from a practice point of view, for example, with residential tenancy, because the entire that entire area has been designed in a way to allow the parties to deal with matters themselves and not get lawyers involved, to reduce costs, to reduce the technical overlay, to make it more user-friendly in a sense. That it's not necessarily working for everything, and standard forms and so on. In this area of commercial leasing, that's absolutely not the case. Lawyers are absolutely involved, like us, on both sides of the transaction. Lessees have their lawyers advising them. Landlords, owners have their lawyers advising them around the lease, around the terms to go into the lease, around what is being offered, around the rights and obligations that are specified. When we get to covenants shortly, we'll see that, of course, from our side of the table as being lawyers, we need to appreciate that the law implies certain things into the lease, and the legislation that we've just referred to before, implies certain things into the lease. But the parties themselves, as commercial people, aren't aware of that. So they're negotiating and discussing what they want to do, and very often they will give you instructions to say, I want this in the lease. I want this in black and white. That's what I want there, right? You might say, oh, but the law implies that. No, I want it in black and white so the other party can see what I want, right? So that is about putting express covenants in the lease, and then it's a matter for you, in conjunction with your client and in providing advice, to decide how is this best dealt with. Should it be dealt with in terms of relying on the implied covenants, or do we need an express covenant here between the parties? And if we end up with an express covenant, that's what will be interpreted at the end of the day. The intention of the parties in accordance with the wording of the covenant. The drafting here is very important, folks. Right? When you're called to do this, that's where your skill as a draftsperson comes in aid. And whenever you're drafting up language that is in a property law instrument, you must remember that it's more than just a contract, because it gives an interest in the land. And that's important. A lessee has an interest in the land. That interest is recognisable through the exclusive possession that they have once we actually determine that we have a lease. So the other thing, of course, that in developing the lease, you need to make sure that that's exactly what your client gets at the end of the day. A lease according to what property law determines is a recognisable lease, and thus an interest in the land. And if you're advising the lessee, it's absolutely necessary that they get exclusive possession for the duration of the lease, that there's certainty of term, and that the other various things that they want to be able to do come within the parameters of the lease as constructed. One of the things we're going to see next week is that when we start looking at remedies when things go wrong, then we're going to realise that despite the fact we're saying this lease is a property law relationship and it gives the lessee an interest in the land, of course the landlord already has an interest in the land as the owner, right? It also, because of how it takes place and how it happens and the dealings between the parties, it has contractual characteristics. Cast your mind back to term 1. I know it's a fair way back, folks. We've been travelling together for a while, haven't we? It's a bit like on the Greyhound bus, right? We're all getting very used to each other. But if you cast your mind all the way back to actually topic 1 in Foundations of Property Law, you might recall that one of the things that we looked at was the connection and the distinction between property law and contract. And in that context, we spoke about licenses and contracts. And all these weeks and months later, when we look at the law of leases, it comes to bite now, because this is exactly where that connection takes place. And it takes place when we start looking at remedies, because the law has recognised, because of the nature of the lease and the nature of how it's been entered into, the nature of how the parties are dealing with each other, and what they want at the end of the day when problems occur is they can get access to contract law type remedies, as well as the sort of remedies that are available where you're talking about interests in land and property, proprietary interests. So that's more for next week, but that's a sort of broad overview. So just also to give you a little bit of a heads up in terms of the questions. So we're looking, I've got 2 questions that I put down from the Q&A book covering this topic, and that's question 3 and question 5. Now we're going to cover question 3 tonight, and we're going to go into question 5, but we're not going to finish 5 because question 5 actually takes us across into the topic of assignment of leases, which we'll deal with next week, as well as looking at remedies. So in question 5, you can see, it's on page 185 of the Q&A book. There's information there, and then there's A, B, and then over the page there's C and D. We're not going to do with C and D tonight because that deals with the assignment issue and the remedies. So we'll deal with that next week. So this week we'll just do A and B when we get to question 5 shortly. All right, so let's come to question 3. Now, I know that's been an intense week for everyone, folks. I appreciate that, I do. I say that with great sincerity. Can't you hear it in my voice? Sincerity, it's great sincerity. Just want honest position. Are people across this, or they like me to just basically prime move things a bit, or how are you feeling? Just let me know.
Across the first part of it, at least.
First part?
Yeah, I'm across most of the first part, Mr. Corbett.
Good. I'm not across it. Eve, hold our hand. That's all right. That's all right. All good, folks. All good. How about we start like this? So, have you had a chance to read question 3? If you haven't, is everyone just yes, no? Just say yes or no in the chat box. It's a yes. It's a yes. It's a yes. It's a no. It's a yes. It's a sort of a yes. Mostly yeses, a couple of no's. All right. We'll just take a couple of minutes to let folks that haven't had a chance to read question 3. It's not that long. Just on page 176. Just have a quick. And those of you that have read it, just a quick reread of question 3. Just give you a couple of minutes to do that. All right, so what is the, when you read, before we get to the sort of strategy of the answer and so forth, when you read that information, and you understand that this is a question, you know, putatively about the area of leases, what comes out at you from the facts or from that information in the question? What strikes you immediately, hits the radar?
For me, it's the fact that if the hirer does not show up, they can be leased out to someone else.
Okay, that's good, Tasman. Thanks for that. Anything else?
The word's hire agreement, actually.
Good, good. Well spotted, Peter. So the language or the terminology or the nomenclature that's used, okay, that can cut both ways. So in this situation, a hire agreement, that phrase has been used. Sometimes parties can try to be clever. They might want to camouflage what they're doing, okay? And they mightn't have got the lawyers involved. Or they might have got the lawyers involved, right? But not necessarily. But when I say it can cut both ways, is that they could also call what they're doing with each other a lease. That doesn't, because it's got that label, it doesn't mean that it is a lease, right? This is a thread that runs through the law in a strong way. That is, we're not focusing on labels. We're not focusing on headings. We're always asking what is the relationship as a matter of substance, and examine what the parties have done with each other, examine what they've entered into. If they've got, in this case, there are particular terms of this agreement that have been specified. We need to systematically work through each of those to work out what we actually have here. All right. So that in terms of that, and the fact that they don't seem to have this all the time, and that there are specifications around what they can and can't do, and Jeannie, I think, and Keith, what they are allowed to do with regard to these areas that they're actually so-called hiring. This brings up really a question about whether this is a lease or what else might it be seen to be, something that you could otherwise describe it as.
License?
Yeah, yeah. So how just in general terms, what is what can we explain what a license is?
I'll have a go.
Thank you.
It's an agreement to use a particular space for a particular purpose that falls short of being a full-blown lease.
Yes. So it gives access, it gives use, it specifies a purpose of some description, and the license can be revocable or irrevocable. You might remember cast your mind, as I said, right back to that early topic in term one. We looked at the Cowell decision, where the person went onto the race course, and the question about being, the license and the license being revocable to go on and off, and was tossed off the race course because he was, betting in the wrong way or whatever. He was a bookmaker, I think. So that's right. It's about access for a purpose. Good. That's well spotted, Eve. So maybe you're holding our hands. So that's right. It falls short of creating an interest in the land. But of course, remember, historically, a leasehold interest did not create an interest in land either. Remember, historically, it was considered as a chattel real. We're still going back into our term one studies. Remember when we looked at estates, right? And we looked at all that. So, but for a considerable period of time now, a lease is a recognisable interest and it creates an interest in the land. So this scenario in question 3 is essentially asking, do we have a licence? Do we have a lease? And the essential characteristics of the lease are, give them to me.
Exclusive possession.
Exclusive possession. What's the other one?
Certainty of duration.
Certainty of duration or of term. Thank you, Eve. And this question is really looking at this idea of exclusive possession. Notice that we can distinguish between possession and occupation. Okay, we can occupy land. It doesn't mean that we have that exclusive possession. Remember, early in the unit, in the term 1 unit, is that right? Yeah, in the term 1 unit, we looked at possession. We did a topic on possession, what possession meant under the law of property. Okay, so that's what we're focusing on, whether or not there is exclusive possession. And you can see that the answer goes through and looks at each of these clauses: clause 1, clause 2, clause 3, clause 4, and clause 5. So if you have a look at these, go back and have a look at clause 1. The hirer is entitled to exclusive occupation. It doesn't say possession, it says occupation, and use of stall numbers A1 and A2 for a period of 1 year from the date of the hire agreement. A diagram is attached. You have to ask whether that gives exclusive possession according to what the law determines. And you can see in the answer, Redation Smith, which is a foundation case in regard to this idea of exclusive possession. And you can see there on page 176, what do we need to establish? That there is the intention of the parties as demonstrated by a prima facie reading of the words in the agreement, the actual rights granted by the clause, and a review of whether the actual rights granted match the apparent intention. Is there this idea that the lessee was able to have exclusive possession for the duration of the lease interest? So what does, practically speaking, what are the attributes of exclusive possession?
They're the right to allow people on and off the property or the premises, and to exclude people from the premises.
Importantly, who?
The whole world.
The whole world? That's a big world out there, Nicholas. Nick, big world. But there is one party in particular.
The landlord.
Exactly. And that's what, because the landlord doesn't have the right to come on whenever they want to, basically. This is what is a defining aspect, that the lessee has this exclusive use and occupation to the exclusion of others, but importantly, the landlord, who can only come on with due notice and with the acknowledgement of the lessee, unless there's some serious matter at stake. But importantly, the landlord or the lessor, just because they're the owner of the premises, can't just come on whenever they want to, because the lessee actually has an interest in the land, and that is constituted by their exclusive possession. This is what partly gives the recognition that when we have a valid and effective lease established, we actually have a split of interests in the land, so that the lessee has exclusive possession for the duration of the lease. What the landlord has, whilst the lease is on foot, what do we call the interest that the landlord has?
The reversionary interest?
Reversionary interest, that's it. That's well said. So, the reversion, folks, the reversion, okay? And what we'll see next week is that both of these interests can be transacted in. The lessee can assign or transfer their interest, and the landlord, of course, can assign or transfer the reversionary interest by selling the property. They can sell the property. It's their property. They are the registered proprietor. They can sell it. They can sell it with a lease in situ. Lessee in situ, a lease on foot. In a commercial situation, in commercial land, commercial premises, that is something that happens. It doesn't happen in an occupation or residential situation, because mostly the owner wants vacant, an incoming owner wants vacant possession because they want to occupy the land, right? Or the premises, the dwelling. So that's a different situation. But in a commercial situation, that can happen. Then the other thing is, and we'll get to this next week as well, but the lessee can not only transfer or assign their interest, they can do something else. What else can they do?
Are we talking about subletting?
They can sublet, precisely. So we then, and we'll see this again next week, this distinction between an assignment of the leasehold interest, which is actually the transfer of the entirety of the interest, as opposed to a sublease, which is actually almost like dividing up the premises, where part of the premises have then been leased to a sublessee, where the lessee actually becomes the head sublessor under that sublease, if that is established, and you can prove it. More on that next week. So, all right, so coming back to this question, right? So we've got clause 1. What do you think? Does that give exclusive occupation? It talks about exclusive occupation and use. Is that enough to satisfy Radation Smith in terms of exclusive possession?
No.
No. Why so, Peter? Why so?
Well, exclusive occupation and use of the stall the word occupation doesn't equate to possession, for starters. It's only just you're allowed to be there while you're there.
That's it. Mm.
And the use of the stall, yeah, fine. But it just doesn't. It doesn't sort of stack up as same as possession does.
Yeah, no, that's right. And don't forget also that this is only happening on alternate Saturdays each month. All right, so that's in the initial information. Okay, so when you've got a scenario like this where you've got specific clauses or specific terms within a legal document, like a lease, and you've got preliminary information, you must read these in conjunction. Okay, very important to do that. Okay.
Find it interesting, Michael, in the actual case, when you read over the answer, that it says the designation of specific stalls could arguably support a lease, in that it conclusively identifies the area to be occupied by the hirer and does not leave any leeway for a JK to have the right to move the hirer within the premises, which is more likely indicative of a lease.
Mm. So, and that's well spotted, Nicholas, because it's also indicative that you can argue both ways very often. This is one of the points actually that I want, and I mean, I don't know you folks whether you've submitted your assessment or not yet, but it's in the first assessment, it was interesting that a lot of folks just didn't seem to get this bit. That is, that you can actually argue things both ways. They came in with this almost like a preconceived view and interpretation of the events. mean, for example, and I'm sort of side shifting a little bit, but just as an example about problem solving, right? So that in that case, in the 20% assessment, Teresa, right? Everyone, not everyone, but a large number of students, oh, she's done the wrong thing. And it was just, I could get it, I could sense it coming through the writing. It was a preconceived view. That's very dangerous, folks. If a client comes to you, you have to listen carefully to what they say. You have to scrutinise the information objectively, dispassionately, objectively and dispassionately. Who was Teresa? Oh my goodness. Teresa was in the 20% assessment and she was with the brother and she went to the bank and etc. Okay, so there's a reminder assessment. But the point of the story is scrutinise the information and don't make assumptions based on preconceptions about interpreting behaviour before you adequately scrutinise it and evaluate it.
Yeah,
very often it's put in a way to suggest something with the desire for you to investigate further. Nicholas, yeah?
Yeah, I was just going to say, I don't know about everybody else, but I didn't necessarily believe she was in the wrong to begin with, simply because, number one, although she had the electronic signature and how she used it, there was a small footprint in there to say that her brother knew she had it. So there was no indication either way whether he was allowing her to use it in the future or not. So you couldn't really say whether she was, you know, breaching any laws, because they may have had an agreement that we weren't privy to.
That's right. And the other thing is you've got to look at how information is presented. You know, and obviously in this case it's mostly communicated to you in writing, but doesn't need to be. It could be an oral, you know, could be orally communicated. And very often that's how clients come to you and they talk to you about things. But these two individuals, and we'll come back to the question in just a minute, but these two individuals actually were connected together in two ways. They were siblings, and as I pointed out to many students on their assignments, of course they didn't point it out, they missed it, I think it's very arguable that they were business partners. Very few students picked up on that point. They immediately characterised them as siblings and beginning and end of story in terms of how they were dealing with each other. And how dare Teresa, etc., etc. And once the assumption had been formed, everything followed after that. Well, I'm sorry, folks, but that is not rigorous legal analysis. And you have to scrutinise the facts and the information that comes before you, right? The reason it's really important for you to do that is because clients come with a disjointed story very often. They come full of passions about the situation they're involved in and the wrong they've suffered, etc., etc., and what they want and what they demand and so on and so on. You have to break that down. You have to dissect that into get a logic in terms of what's transpired, what the law has to say about that, and then how you can put it back together again in terms of what do you think your client is entitled to or has an obligation to according to law. But you have to be, don't rush in with assumptions. Let the information reveal itself through careful scrutiny and analysis. Okay? I'll say a little bit more about problem solving in the consultation hour and also about how I think it's good to use law in problem solving situations. So that's right, and that's good. I think the first one, look, there is an arguable point there, and things could go either way. But I think the language is, it's being used in a way that is not strongly enough suggestive of the necessary requirement of exclusive possession. What about number 2? If the hirer does not use any of the stalls for a particular day or month, then JK may allow other persons to use those stalls.
Well, that goes to being again against exclusive possession, because they don't have exclusive possession.
Yeah, and it actually, as the response there indicates, and this goes back to Nicholas's point, it in a way, the first one seems to be a little bit more moving in the direction of something that looks like exclusive possession, though it may fall short. The second one actually seems to work against that by almost allowing the owners here to come in willy-nilly, right? So that certainly doesn't seem to satisfy the requirement. What about 3? 3 talks about hirer must pay rental to JK before the end of each month. The rental payable is calculated by the number of stalls actually used during the month.
No set rent.
Exactly. So, and the other thing too is that rent is not actually a fundamental characteristic of a lease. Now, whenever this comes up, but I teach the law of leases to students, it's the first thing they get a shock. Right? So what are you talking about, Michael? What, rent? Rent is not the fundamental. Of course it is. That's the reason we're doing it, isn't it? Well, we're talking here about how the law defines a lease relationship under property law. And rent is not a fundamental characteristic, even though practically speaking, it's the reason why the premises are being leased or the land is being leased. But it's not a fundamental characteristic. Very important to grasp that. 4. Now 4 touches the hirer must keep the stalls in good repair and sanitary order. JK may enter and inspect the stalls at any time. What about that?
No exclusive possession.
I'd say it's more consistent with the principles of a license in that context, because in a license agreement, you're basically told, what you can and can't do and what's inconsistent. And that's exactly what it's talking about. That's right.
But it does, touch on this idea of, it's suggestive of this repair, and then we'll come to that in the next question, this repair covenant, this idea of an obligation to repair. But again, don't assume. See, some people, some students will look at that repair. Oh, that's about repair covenant. Don't assume. Scrutinise the information with care. Can I say that? I'll say that again. Scrutinise the information with care. Care and concern, folks. Do not make assumptions. Okay.
You mean leave your bias at the door?
We don't have any bias, do we, Nicholas?
It's pretty biased to say nobody has bias, Michael. Go on.
That's right. So look, you have to be, as we as lawyers, our role here is to be objective and dispassionate as much as we can be. No one can be completely objective and completely dispassionate. And I can tell you, when I was in law practice, I had some very challenging scenarios, not so much in property law, but in other areas that partners would toss to me. Very difficult, very, very difficult at times to be totally dispassionate, but you have to be. You have to strive to be, because that's your role. Your role is to be an independent professional advisor for your client, okay? You also cannot make the commercial decision for your client. You're providing legal advice if that's the role you're fulfilling. Now, I know today, and you folks will emerge from your studies with us into a brave new world where there's a whole lot of new opportunities of employment and working as lawyers in a whole lot of situations. But if you are working in the more traditional context, in whatever virtual environment or whatever environment you inhabit, you are a legal advisor providing legal advice. You're not the commercial decision maker. So, for example, in the scenario of a commercial lease, you're not the one making the decision about whether to undertake the lease or not. You are providing legal advice with regard to the legal implications of what the client wants to do commercially. and your role here is to make it as best a legal fit and provide them with the strongest rights and protections according to law that meets what they're seeking to achieve commercially through this venture. Now, sometimes our colleagues get a bit confused about, are they the legal advisor? Are they sitting with the client making the commercial decisions? You've got to be very careful about this. Right? So you are a legal advisor if that's the role you're fulfilling, and that's not about making the client's decisions for them, but very often that's what your clients want you to do. Because they say, well, you know what it's about, you know what's involved, whatever, what would you do? That's not your role. Your role is to guide your client towards what decision they feel is in their best interests, but you can give them the best information around the law and how that affects their situation. Okay.
Sounds like a minor in psychology, mate, because psychologists never tell you what to do either. They make you think about the answer yourself.
Well, there's an aspect to that. And, as lawyers, we are working with the psychology of our clients. And you come to read your client. And if it's different situations, of course. I mean, if you've got a new client, that's a different scenario. You don't know their background. You don't know what sort of things they're involved in and whatever. But if you've got an existing client, you know the nature of their businesses often, you know what they like to get involved in, you know the things they're prepared to do, you know their levels of risk, you know their levels of funding, and a whole range of things about their situation. And yes, you're judging the situation, but at the end of the day, you must also remember that we have, yes, of course, we have primary obligations to our client, we have higher obligations to the court, we have ethical duties and responsibilities. So there's a whole array of things that we have to bring to bear in what we do as lawyers on a day-to-day basis, almost intuitively. You can't be running off to books and resources around all of these features and aspects at a moment's notice when a client wants a response. But having said, and particularly with the technological environment we work in, where clients are almost expecting responses yesterday or instantaneously. But on the other hand, you have to also be able to communicate to your clients that, no, I need to look at this a little bit more closely, and you need to give me some time to review this so that I can properly advise you. And then you've got to find a way to create that time within a very busy practice situation, which most lawyers find themselves in. And even when you start off in a firm or whatever, you might have partners coming here, several partners and coming in different directions, giving you a whole range of things. You've got to sort all that out, and you've got to give whatever matter is that needs attention the appropriate degree of attention. And you have to decide what that means, because there are implications, and sometimes serious implications, of not doing so. Right. So we've got the repair issue. What about the right of termination? That's 5. That's the last one. Either party may terminate this hire agreement at any time by giving 1 month's notice in writing. However, JK may terminate without notice if the hirer fails to pay rental, fails to repair any damage to the stalls, or otherwise misbehaves.
Yeah, it's a pretty neutral clause. It can go either way. I don't think it has too much weight as far as the overall. I'd be looking at the first 4 points. It's pretty neutral.
It is. But what about this idea of basically being able to terminate without notice? Anything in that? Does that tip it one way or the other?
I don't think so, because if you go back and you do want to cross-reference that with anything, you can cross-reference it with the fact that the amount of money that they pay is not regular either. So the one sort of terminates with the other in the sense that, well, we don't know what we're paying and if we're going to be paying anything, so we should be able to terminate at short notice or no notice anyway.
Yeah, yeah. No, I think that's fair. That's fair. Okay, so the point, I just want to point out to you on page 179, right, these little tips I think are quite useful under the keep in mind. Second point there, students should not assume that the factual existence of exclusive possession means the hirer has been granted the right to exclusive possession. That's quite important. This goes to the language of expression, right, of how the nature of the right is explained. And that goes to my earlier point about careful scrutiny of the information. Very important, careful scrutiny of the information, and don't jump in making assumptions, but let the language speak to you in terms of what's actually happening and taking place.
Well, I guess you made the point that just because a document says it's a lease doesn't mean it's a lease. And in this instance, just because it says it's a hire arrangement doesn't necessarily mean it is either.
No, exactly right. So the labels which parties often choose themselves is, in truth, neither here nor there. They may be indicative, but we need to examine the substance of what the parties have committed to, what their intentions are through the language that they've captured to express their intentions, and against the legal requirement then to decide whether or not it is, in this case, a lease or no. All right. All right, 10 to 8. Let's soldier on to question 5. Just before we do that, and this takes us into this, I just want to screen share with you. So don't forget the legislation, folks. All right, this is the Property Law Act. Okay. So we've got Part 8, Division 1, the rights, powers and obligations. Right, there's a 105, obligations of the lessees, 106, obligations in short leases. Right, and that idea of short leases is not the same in all jurisdictions, okay? But in Queensland, it talks about a term of 3 years or less. Right? And then we've got the power of the lessors to enter and repair. And these are the matters dealt with under the legislation. So very typically, these are the implied covenants coming from legislation. Short form covenants and various other matters there. And then we'll come to these matters later when we look at next week. Right? So 105 and 107 a bit coming up in a moment. So I'll just stop screen sharing that. And also remember that, again, you've got that the property law review, which, again, it's a big chunk of the review, you know, dealing with leases. But just have a look at some bits of it, have a bit of a flick through it, not needing to read it in detail on this particular topic, but just be mindful of it. And again, it's proposals for reform. It's not the current law, but just have an awareness of that.
It's interesting that you brought that up because that was done in 2016 and there's another one underway now due to the fact that there is this premise that the next generation will not be able to buy land and so that they may be renting for the rest of their lives. So they're looking at changing the way that leases, especially around rents, are structured.
That's really, I think, more residential situation, Nicholas.
Yeah, it's particularly residential, not commercial, that's for sure.
Yeah. So that's not covered by these provisions, okay? So the residential tenancies is covered by the Residential Tenancy and Rooming Accommodation Act 2008. What we're focusing on is general law leases that today are mostly commercial leases. Okay. So that review that I was referring to is a review of the Property Law Act, and I think what you're referring to is possibly a review that's on foot with regard to the residential tenancies legislation, which actually hasn't, the Queensland version hasn't been reviewed for a while, so that's probably timely. All right, so come across to question 5. Have people had a chance to read question 5, or like to have a look at question 5? I'll give you a couple of minutes, all right? Just let you read. And by the way, we're only doing down to B, which is at the bottom of 185. Don't need to go over to 186 in terms of the question. We'll come to the answer and so on. But just read the information for question 5, and then Angela and Blake, seek your advice, A and B. That's all we're doing, A and B, okay? So just give you a couple of minutes to have a read through that. All right, so I had a chance to read through that. Yeah, it's good. So this is a very different situation to the previous situation, okay? What is, again, I'm going to ask the same question. What, just from the information, don't worry about the requirements at the moment, what strikes you? What hits you, comes out at you from the scenario?
They have to maintain.
Usman, yep.
So it says here like they have to maintain the property, like in all the, what is that? Sorry, they have to maintain the property in all ways.
Yes. So they, who's they?
Who are leasing the property.
Okay, so there's information about what the lessees are required to do. Yes.
Yes.
Yes, that's good. What about the situation, Peter?
I hate to sound like a broken record, but there's nothing in there to say exclusive possession of the rented premises.
Oh, okay. We'll get to that in a moment. What about anything about the situation generally?
Well, I'm behind this week, but I would think that if you are leasing a property that basically like your structural or that sort of damage that has occurred that isn't actually the fault of them, I don't see how that can be something that's the people who are leasing it actually has to fix. I mean, if it's an actual building issue,
good,
that's
yes,
not their responsibility.
So Tasman, you're suggesting
there's a body corporate arrangement in there somewhere.
We put that to one side for a moment, Peter. We'll come that. So to get back to you, Tasman, because it's a good point you've made. So you're distinguishing between things that the lessee's doing and how would you describe these other things?
General maintenance, or actual more structural of the actual.
Yeah, structural. Yeah. Therefore,
wear and tear. I don't know.
No, when the lessee comes in, if they're already there, how might you describe them?
Existing. No.
Yes. Yes, exactly. It's good. It's good. We talk about things being inherent. All right. So you might come across this sort of idea of inherent defects, maybe, or inherent problems.
Yeah, I mean, just going from general, what I know about people renting and that sort of stuff, if there's like a burst water pipe, essentially like in a rental house, it's not up to the person who's renting it to fix it. That's more of like the owner's.
Yep. Again, I have to emphasise you need to differentiate a residential tenancy situation that's governed by the Residential Tenancy and Rooming Accommodation Act and a commercial situation that's governed by the law that we're looking at. Okay, so don't get those confused, folks, even though they're both landlord and tenant scenarios, but the law that governs them is different. So don't get them confused, okay? But we are talking about landlord obligations, lessee obligations, landlord rights, lessee rights. And in this idea of issues with the property, we can differentiate between things that are the responsibility of the lessees, maybe things they've done or haven't done, or their obligations to keep up the repair and keep it habitable and so on, as opposed to problems that were there when they came in. Now, there's the word you used, Tasm, was structural. That's what triggered, that's what sort of tweaked at me. Structural. That means that it was part of the building. If it's part of the structure of the building, how could that be the responsibility of the incoming lessee? Because it's there before they even arrived, isn't it? So you're scrutinising the information to look be on guard for these differences of explanation in the facts. That will then lead you in the direction of who has the responsibility and the law that governs that. Okay. Now, the other thing is, what about just the practical situation? What's the environment, the practical environment in which this situation arises?
Would you call this a retail shop lease?
No.
Or no?
No, that's good. It's good. But I like the fact that you've posed a question. You haven't assumed that it's an RSLA merely because it seems to be about that type of a situation. Okay. And what's the nature of the business that's being run? What are the lessees doing? Sorry?
An accountancy firm.
Yeah. And I've got someone waving behind you, Lee. Can I wave back?
I'm not sure if you realised that I was watching you live, so I just...
It's all right. So we've got here a situation of possible retail shop lease scenario, but we've got to be very careful here, right? And over the page, there's discussion of the RSLA, right? And also be mindful the RSLA has been amended in 2016. I've given you that information on the Moodle website, okay? Now, the reason I say this is because the RSLA is very particular about what it applies to. It has to be in a shopping centre. It has to be of a certain configuration and size. There are quite specific requirements. Even if you were effectively operating a shop in a retail situation in a complex, if it didn't meet the specific definitional requirements, it still wouldn't be governed by the RSLA. And it would then be governed by the general law. In any event, even if the RSLA does come into play, the effect of that act is that it's a combination of the general law and the RSLA provisions. I want us to put the RSLA to one side, though. Let's assume this is not an RSLA situation, but it might be, and you need to be a bit attuned to that. But let's assume that this isn't that. Let's assume that it's governed by general law, and I think that's potentially the reality, maybe anyway. This question is really moving us in the direction of the covenants, okay? And as I showed those to you before in the Property Law Act, so we've got Section 105 dealing with obligations of lessees. We've got Section 107 dealing with the powers of the lessor. These are the covenants that are implied by law We also have the express covenants that the parties may have themselves entered into. Okay? And in this case, we actually have specific clauses that have been put into the lease by the parties. Now, again, as I was saying earlier, in a commercial lease situation, the bargaining power is often far more at parity between lessor and lessee. Unlike in a residential situation where basically residential tenants come in and have to, it's fait accompli, you take it or you don't take it, and there's 500 others waiting, right? In a commercial situation, because the lessee wants to do things to the premises, the lessee is in a bargaining situation in terms of what can and can't be put into the lease. So that's something that needs to be appreciated. So you can see there the response looks at, firstly, the issue about repair. Well, this comes back to Peter's point originally. We need to determine that we have a valid lease. Okay. Now, this is not just about the characteristics of exclusive possession and certainty of term. It's also about understanding that, do we have a lease enforceable at law, or do we have a lease that needs to be enforced in equity? Do we have a lease that's registered under the LTA? These are form requirements. You might remember, go back to term 1, foundations. You might remember the exam, probably don't want to remember the exam, but in the exam, there was actually a question that touched on these matters of form. You might remember contract for sale of land, and part of what you had to investigate were the various form requirements met for there to be a valid enforceable contract for the sale of land in that particular scenario you faced. A similar situation arises here. We have to have certain form requirements met, and we can see good old sections 10 and 11 of the PLA popping up again. Have we had the form requirements met for there to be a lease? Have we got the other factors of exclusive possession and also certainty of term? We've got a fixed term, and despite what Peter said earlier, I think we probably have got exclusive possession. And have we met the form requirements? Do we have a registered lease? If we don't have a registered lease, then we're talking about enforcement in equity. Have we got, you're also looking in the context of a Torrens lease, what is the duration of the lease? And then we need to think about, is it a short-term lease or not? Because the PLA, just screen share this with you again. Section 106 deals with the obligations in short leases. Okay, and then I'm just going to go up and just do this while I've got you on. Go to the Land Title Act. And there we are. So we've got Division 2 of Part 6 dealing with leases and the registration of leases, and you can see various provisions there. Validity of an unregistered lease, Section 71. So in thinking about leases, folks, you have to remember not just the PLA, but you also have to remember the provisions of the Land Title Act as well, because we're talking about Torrens title in Queensland. All freehold is Torrens title, okay?
Just looking at this question though, Michael, it's not very clear whether they've actually signed a lease agreement, because it says they were given a draft lease agreement and a disclosure statement. It's not very specific whether 3 days later they actually signed an official lease. It just says that it was effective from.
Well, it says all the parties then signed the lease on the 4th of December, with the lease to be effective from the 1st of January.
Yeah, correct. But the sentence before that says they were given a draft lease agreement. So did they end up signing the draft agreement or an actual lease? It's not clear.
Well, it is clear, I think, because the language is different. So it's good to point that out. But again, we need careful scrutiny because there's a difference between a reference to a lease agreement or an agreement to lease, which is something that is actually a contract in effect, and an actual lease itself, which is a property law relationship. And the language here talks about a draft lease agreement on the 1st of December, and then it talks about the execution of a lease on the 4th of December. So that is the entry into a property law relationship on the 4th of December. But there was an agreement to lease on the 1st of December, which was in draft form. Now, if in fact they had not entered into a lease, that then raises issues about the rights of the parties and the obligations under an agreement to lease and the enforceability of an agreement to lease.
Yeah, well, that's why I raised it, because clause 3 is another thing that grabbed my attention in relation to that, because it says the leasee shall not sublet or assign the lease unless, and then A, this is where it gets confusing, because the assignee or sub-assignee's financial viability and experience in the relevant industry are acceptable to the leaseor. Now, if I'm taking a lease and I'm subleasing it, am I not then the leaseor to the subletter?
No, you're the sublessor, not the lessor. Effectively, Nicholas, what that is saying is that no subletting situation will be able to take place unless it has the approval of the lessor. That's the effect of a clause like that. And it's also talking about the financial situation that will be acceptable to the lessor. So in other words, it means that the lessor is happy with the situation of the financial circumstances of that other party. That's the effect of that clause. But sometimes, I mean, it's indicative that things can get a bit involved and there can be restrictions within the lease about what can and can't be done. Okay, so I'm just going to stop screen sharing that. Enough of the LTA. Just to be mindful that you've got to be aware of provisions of the PLA, provisions of the LTA with regard to leases, okay, commercial leases. So we need to establish whether we have a lease. I think we do have a lease. Then we look at the repair issue and the obligations of the lessee here to keep the premises in good and tenantable repair, and what does that entail? And then we've got the issue about the structural repair and what are the obligations there? And then we go back to Tasman's point about the inherent defect. Come back to the facts, and there was a problem with water leakage that arose from a structural issue. Yeah, that goes to the point about inherent defect. And inherent defect is not the if you can establish that, that's what you do. You have to establish that. Now I emphasise. Sorry. I emphasise that you have to establish that. In the first assignment, that's not what several folks did. What they did is they looked at something and then they made an assumption on the basis of what they were looking at. They didn't follow through with a process of logical reasoning to establish an outcome. Just saying, you know, something is, someone does something and saying, oh, well, that's not right, and therefore this is the outcome. That's not a process of logical analysis that leads you to that conclusion. And it's not actually good enough. I'm sorry. You have to go through a logical process of analysis to arrive at the conclusion. You can't just see something and then draw, you know, by osmosis, the outcome out of that. Doesn't work like that. Okay, I'll say a bit more about that in the consultation session shortly. So that's important. You're picking up on that description about something like that, going back to the facts, looks like it's an inherent defect. What does that mean? That would, if we can prove and establish that, that will be the responsibility of the lessor, not of the lessee. So that's around the repair covenant. We've got a specific term that's been put, into the lease by the parties, but we're also looking at that in light of the implied obligation or the implied covenant that comes from the legislation. So an express covenant as opposed to an implied covenant and what the law says about the nature of those obligations. Right, so that's as far as I wanted to go at the moment. We'll deal with the balance of that problem next week. Derogation from grant and also assignment and remedies. And we will also go and I think have a look at the last problem there, which is question 6 as well, because that also helps us to have a bit more of a think about remedies, which are really important. Can't emphasise enough, folks, and I know I'm a little bit over, I'm sorry about that. Can't emphasise enough that this area of leases in this unit, I think, arguably is one of the most practically useful areas for you going forward. Because if you're involved in property law from a practical point of view, it's really invariable that you will be involved in advising clients with regard to commercial leasing. It's a very typical area of property law practice. Some of the other things we've looked at are more conceptual, more doctrinal, and it's important understanding for you to have, but people don't walk in the door with an issue around exceptions to indefeasibility, for example. It may come up in the course of something, of course, and that's part of the learning that you need to have in this area of the law, which is important. But this is an area that is very practically useful at the end of the day for people that think of being involved in the area of property law in a practice perspective. And the other thing too is it's a very common thing out there in the world, leasing, leasing of premises to run businesses and so on from commercial premises and buildings. It's very typical, very common. Okay, so it has a very practical, real-world application, but there's a structure and there's a terrain to the law that we need to grasp as lawyers and see how that works in this context. All right, folks, there we are. We'll bring things to a class to an end there. Now, what I'm going to do is I've foreshadowed that I'm going to offer a consultation hour tonight. I was going to offer it from 8, but anyway, we've gone a bit over time. So I've said I would offer that from 8:30. Okay, so we might just take a 5-minute break if that's okay. Get a cup of tea, and then I'll come back in. Now, what I'm proposing to do is you don't have to stay. That's the first thing. Second is that I'm really was foreshadowing it as a bit of a drop-in session for people just to come in. So I'm not necessarily going to record the whole thing. I don't know whether you want me to do that or not. You can say yay or nay now if you want to. It just depends on how long people stay and how many questions they've got or whatever. But is that okay with folks? So how do you want me to do this? Right? I'm happy for those of you that are here and want to stay around for a little bit. What do you want me to do? How do you want me to proceed in the consultation time? Because we've finished the class now. So what I propose, is that acceptable? What do you want to do?
Sounds acceptable to me, but I'd record it either way, Michael, because you just never know.
No, you never know. That's right. You never know. And it's always, the good lawyer's approach is, what we say, proceed with an abundance of caution. So it's a great carrying call in the law, proceed with an abundance of caution. So, all right, look, I'll tell you what I'll do. I'm going to pause the recording just for, say, 5 minutes. Is that okay? Get a cup of tea. And are you off, Peter? You're going? Yeah, okay, that's fine. Who's going to stay? Everyone going, or is that half of this and 6 of the others?
No, I'll stay, Michael. I can't get Ronnie Corbett jokes at the end.
Okay. Are you staying, Eve?
Yeah, I'm staying because I'm paranoid. I'm worried that you might say something that'll stay with me forever.
And Tasman is, Usman's going. That's right. Are you staying, Tasman?
Yep, I'll stay.
Okay, all right. 5-minute break, folks, and then just get a cup of tea and I'll come back, all right? Just going to pause the recording, all right? So there we go. So this is the consultation session following the class in week 8. Now, what I want to say is that just in terms of some further feedback on the first assignment, it's a lot of pleasing work in that first assignment, which was very very heartening to see. But one point that, and I've already made the point about assumptions and not sufficiently scrutinising information. So I made that point in the class. I don't want to reiterate that or repeat myself. But there is still a tendency for students generally, not all students, but so, I mean, better students don't tend to do this, but there is still a tendency to drop all the law out into footnotes, almost as though you're writing a textbook, right? I don't quite know where this habit comes from. Maybe it's about, you think, oh, well, you've got this tight word limit, so I can't possibly incorporate any law into my text of my answer or discussion. The truth is that that's what we are looking for. We are looking for you to be selective in discussing the law. You have to discuss the law. It's not just all fait accompli. This is the statement, bang, see the law. This is the statement, bang, see the law. I want to see you discussing the law to some degree. You have to obviously be selective when you're on tight word lengths or page lengths. Yes, and that's always the case. But you choose your mark in terms of what sections of the legislation or decisions of case law you want to talk about. Okay, so there needs to be some of that reflected in your answer, not all just dropped out the footnotes. That's one point I want to make. Second point I want to make is that you can't just make assumptions that the body of case law decided in a context which is not on all fours with the scenario you're facing is directly applicable. The whole purpose of giving you a situation that is different or in the modern context that isn't reflected through the factual matrices of the cases, decided cases, is to not to say that that body of case law is irrelevant, because that's not the case, but to see how you're arguing that it does apply to this modern context, particularly in the midst of technology, which I'm often throwing you into. So that was one of the challenges of that particular assessment. The other thing, and this is really, again, getting back to the scrutiny of information, is that on that first assessment, today, the environment of transactions and communications are electronic. That's how most of transactions and communications are taking place, electronically, right? In property law and land transactions, just because you've got electronic documents doesn't mean you've got a full electronic conveyance administered by PEXA, okay? And so you've got to be careful about that, okay? Even though you've got electronic documents, it doesn't necessarily mean you have a full electronic conveyance. But part of what I was getting you to think about in that first assessment was some of it was a full electronic conveyance, certainly when I was getting you to do the NMF inside the PEXA learning environment, but the scenario itself was not necessarily that. So again, some folks are making some assumptions about that. So just got to be careful about that. And then the other thing is, if you're asked to do something, asked to advise a particular party, asked to present something in a particular perspective to a particular audience, for goodness sake, do it. don't just undertake a general academic analysis exercise. Because the whole purpose of getting you to think about it from a particular perspective is to communicate to a different audience, to put the information into a different lens of communication, if you like. Because as lawyers, we have to do that in a range of ways, from a range of perspectives all the time. That's what we're called to do. Okay. And moving forward into the current assessment, if you're doing, that first question is about presenting to the partners of the firm, right? So you think about that, that's the context. If you're doing it as a multimedia presentation, then need to think about how you're going to do that. And if you're doing it as a group, don't forget to include your verification of identity. That's about the involvement and the participation of all group members and identifying that. And also I've given you, today I've sent out an email just giving you a few more options in terms of feedback that you might find that's right for you. I'm giving you a few options in that regard in terms of how you can get the feedback. Yeah, so they're just some general comments that I wanted to make. But really the rest of the time's over to you.
Well, I have a quick question, Michael. Just in regards to question 2 and question 3 respectively. Not that you're going to give away too much information, but out of those 2 questions, which one do you think has more points that need to be covered in the answer? Question
They've both got the same. They've both got the same value, Nicholas.
Yeah, no, I don't mean those type of points. I mean points of argument. How many points of argument do you think there are between question 2 and question 3? Do you think there's more in one than the other? Is the question I'm getting at.
What's your sense?
My sense is that question 3 has quite a few more points to push out than question 2.
What do other people think? Other people prepared to chance their hand on that?
I agree that question 3 probably has more points, but I think the points in question 2 probably need to be discussed further, and that's why there's similar word counts.
Yeah.
That's just the way I'm approaching it. Yeah.
Bit more. You think question 2 is a bit more subtle, Tasman?
Yeah. That's just, but I'm probably wrong. Sorry.
I don't want. By the way, can I just, before you comment, Nicholas, don't ever say that, Tasman. Okay? Because every student question and comment is valuable. And I don't want any of my students to ever self-deprecate the comments they make, because all of your comments and questions are valuable. Okay? So I think that's a good comment that you've made. And I'm just going to leave it there because I think it's a good comment, right? And I do set assessments to try and get a good balance in terms of what I'm trying to test, both in terms of knowledge, but also in terms of skills and areas that I think, I need to, get you across, and you need to develop some understanding of.
Okay, I was just going to say, Tasman, I actually agree with your point. So, and as Michael says, there's no silly questions, because as you would all know, I ask lots of questions and often I'm not right, but unless I ask the question, I don't know. And that's the reason I do it.
And look, that's fine. And my response to that, Nicholas, as you know, which I believe should be is the correct response, is to, air the questions, to give other people the chance to ask questions, but also, if you're not on point, then to correct that understanding. And that's my role, in an instructive way, not in a pejorative way or critical, but in an instructive way. So. But always, look, the thing is, folks, just always be encouraged to ask questions and to seek further information, further clarification. I think one of the challenges in online learning, and it's a learning. It's a continuing learning journey for all of us, right? And we just need to keep reminding ourselves that the learning encounters we have are different to the more conventional face-to-face learning, and that if you've got something that you want to ask, don't be bashful. Come forward and ask it. It's really important, and I want to encourage all of my students to feel that.
So did I read right during the week, Michael, that you've pushed off the 30% assignment due date until Monday? Is that correct?
That's absolutely correct. Yes.
Thank you for that. I was in desperate need of an extra 24 or 48 hours.
Well, I looked at that in hindsight, and given the fact that I didn't get the 20% assessments back to you till Monday, and look, I had issues over the weekend. Not everyone thought that was justifiable that I had issues, but anyway, I did have issues with power and all this sort of thing. But people still thought I should have been in communication. But anyway, there were problems and it didn't happen. Anyway, the long and short of it was that that's when I got them back to you. And I understand, I mean, some people are really super organised, right? And so, there's a few folks who've already submitted their assessment. Well, that's fine. That's according to their schedules and they're very organised, whatever. Most folks, of course, are, submitting up to the due date. And I really understand, that timing here is quite tight. And in hindsight, it might have been better to space them a little bit more. But anyway, that's how it worked. And these decisions, one thing that's important for you to realise, these decisions about the timings are made very much in advance of, when things actually take place. So I think it's important for me to be responsive to the situation at hand. And if I think that a little bit of latitude is justified and is equitable for everyone, then that's what I'll do. And this is what I've done in this situation. And I don't think that giving you an extra weekend, affects the situation, in any way interferes with integrity of process. I think that's just the right thing to do. That's basically, I hope that's helpful for folks.
Yeah.
Thank you. Yeah, thanks.
Yeah, thanks about that. The only other thing it does, though, is it causes a conundrum now, because we've done this a little bit on leases, and it's like, could I fit that into my answer somewhere when I don't have to? Because we're not dealing with this week's material in that answer, right?
You are not dealing with this week's material in the assessment, Nicholas.
No, I realise that. I'm just making the point, though, that now that we've covered this material, it's sort of like I can see how it may fit into the scenario. It's really intriguing how that happens.
If you've read the information about another assessment, then you'll realise that there's plenty of opportunity for the material in this topic to be assessed elsewhere.
Oh, yes. No, I'm well aware of that.
And can I say, just on that point, that you would be well advised to give this topic some serious consideration. Well advised. So I'll say more about that in due course, but this is a big topic. We're spending 2 weeks on it, and there's a lot of material there, but there's ample opportunity for that to be assessed in the last assessment. And it's clearly on the assessment because I've already given you the instructions, guidance on the final exam. Okay, so be mindful of that. Can I just ask, how many of those of you that are here, obviously I can't ask those people aren't here, but how many of you, those that are here, are doing the 30% as a group rather than individually?
Nicole and I are doing it together.
Good, very good. I think Mo, as a group. Okay, I was a bit oblique. Right, okay, there's a group, yep. And Nicholas, Tasman, are you doing it as a group or how are you doing it?
No, I'm doing it individually because with work and other commitments, I don't know.
Fine. Yeah, sure.
Yeah.
And Nicholas?
Yeah, I'm doing mine on my own, only because I had an assignment last week and I've got another one due next week as well on top of yours. So back to back, I'm trying to scramble time. So
it's assignment season. Yes, I understand. And the other question I want to ask is, how many of you, those that are here, are doing question 1 as a multimedia presentation rather than just a text document?
No, yeah, mine will be multimedia for sure. It's one of my strengths, Michael. So it's probably the easiest part for me is part 1.
Oh, that's good. And Mo, yes, presentation, good.
I was doing it as a briefing paper, but now that I only just found out 5 minutes ago that we've got an extension, I might try multimedia over the weekend with it.
Oh, good.
Yeah.
Oh, be encouraged, Tasman. Be encouraged because, I want people to experiment with these different ways of communicating. And look, I have to reveal my hand here. It's more interesting for me to have that dimension of the assessment rather than just constantly having to read document. To have other types of ways that my students are presenting things to me and engaging with me, I like that. And it allows you to present the material, in a different way. And this is actually the presentation aspect. So, that's quite, quite appropriate. And Eve and Nicole, are you doing it as a multimedia or how are you doing yours? There's nothing coming through, Eve. Sorry, you must be on silent.
How about now?
Yep, that's good now. Yep.
Yeah, no, ours is a surprise.
Oh, very good. Okay, I love surprises. Great.
Yeah, we're doing a presentation.
Yeah, good, very good.
Surprise! I didn't think you could send a pinata down the line.
No.
They're going to do interpretive dance.
Sorry, Tasman?
They're doing interpretive dance.
Ah, there you go. Excellent. Very good. Right. So, any other questions, folks? Well, we all sort of a bit done out. It's that time of the semester, isn't it, really? I mean, I tell you what, I think we just get to this stage and it's, we're in week 8, aren't we? Week 8, and just, you get that, it's been a long year, sort of, and just the way it is. But anyway, we keep going and keep our energy levels up. And once all of you've submitted your 30% assessment, we then need to start focusing on these final topics and heading towards the final exam. Okay, so I think the other thing I'll just mention, I don't know if this has been confirmed yet, but I did have early advice that the exam, I think, was being held on the 21st of October. Have you had that confirmed to you at this stage?
Yeah.
And is that the correct date?
I think so.
Right. Okay.
The Monday afternoon. Yeah.
Yeah. Okay. That's
I hope so. Yeah.
I saw. Well, we get early notification about preliminary, but I don't know that they advise us of when it's been final. So that's good. So it's 21st of October, yeah. So it will be done and dusted long before that, and then you'll have a chance to adequately prepare and so on. Right. All right, folks.
I do have a quick question, and yes. I'm behind this week with the reading and that sort of stuff, but I did put it in the chat earlier when we were talking about with the lease and the license sort of thing, about what's the benefit of either party actually wanting it to be a lease.
So I missed that. Just say it again.
So when we're talking about whether it's a lease or a license, realistically, what's the benefit of either party wanting the situation to be a lease? Because a lease is a lot more of a lock-in sort of situation and seems to have a lot more responsibility compared to a license. So I'm not...
Because the lessee obtains exclusive possession and certainty of duration under a lease. A license situation is really just permission of access and occupation, and it doesn't give the same, the effect is that it doesn't really give the same levels of protection to that occupier that has that possession of the premises or of the land if they don't have a lease. And if they have a lease that is recognisable under the law, they have both exclusive possession, which means that the landlord can't come in at any time willy-nilly, whatever they want, whenever they want. And there is a certainty about how long they have that interest in the land for, of exclusive possession. That's important and valuable in a commercial situation when you're running a business or doing something of commercial, with commercial purpose or economic purpose with regard to land. And the other point is that if you're in business and you're operating a business from leased premises or from leased land, as we'll discover next week, and you want to sell the business, you will also want to transfer your interest in the lease at the same time. And that will be of interest to the incoming new business owner. They will also want that degree of certainty and exclusive possession so they can continue to run that and operate that business. So they're the benefits of having a lease.
Okay. Yeah, I understand. I guess I probably was a bit confused. I just read that question tonight and why a market store holder as such would want to have a lease in their situation, because it's usually, it's sort of not a necessarily consistent thing at times. And yeah, so yeah, no, thank you for that. Thanks.
That's right. And you can imagine that, there are a whole lot of different situations where, the owner of the land is trying to generate income from use of the land, but not wanting to tie themselves down in terms of obligations and responsibilities to those that are using the land. But those that are using the land want to protect their position, and they want to have a degree of certainty around what they're doing and for how long they can do it. And that's basically the basis of this lease entitlement that's recognisable through this framework of leasehold interest.
The other point I could make, Michael, is I know that the banks, when you're dealing with small businesses that are leased properties, the banks look at the tenure of the lease, like how long is the lease, how long has it been substantiated, all that sort of stuff comes into play when it comes to small business loans through banks. They want to know that the security of tenure is there for the business owner to actually make the money to be able to repay the bank.
Yeah. So again, as lawyers, you're often involved in dealing with clients that are running businesses, and the effect is that business, and you can have that business can be transferred. Contracts for sale of business, okay, but most businesses have to be, traditionally have had to be run from somewhere, right? I know we've got virtual businesses now, and that's another dimension, but most businesses have had to be run from somewhere. That means they need land, premises of some description, and then this whole issue about certainty, and then the financing comes into that. And so, yeah, it's an important area, and it's one that lawyers are involved in to a large degree for the reasons of what's going on and the various participants in the process.
Yeah, landlord doesn't seem to stand on its own in a commercial world. It seems to be in reference and attached to many other laws as well. It seems to be central to a lot of other laws, I should say, especially around business.
Yeah, that's right. And, we come back to this old adage that you can do very little unless you have somewhere from which to do it. And that requires land. It requires property, and that then inherently takes you into the law that governs those interests and those dimensions. The nature of how this works is being challenged by electronic environments, virtual environments, but in the end, to access virtual environments, you still need devices, and devices are property. And then you come to something we looked at in the Term 1 unit, and that is that what is being stored, the information, the data, what is the nature of the proprietary interest in that? Because the reality is that it's stored somewhere, actually in data banks, in data farms. Right? We talk about the cloud, but the cloud is a bit of an innocuous idea. It's not actually up there in the sky. It's actually in data farms that are actually located in different places around the place, and those are actually sited on land, right? So that raises another dimension of land and so on. So it's
yeah, that starts to get messy around that data stuff, because we're doing a bit of that in e-law at the moment, and it starts to get very messy about data crossing international borders and remaining on servers outside of Australia, and who has access to it, and what power and control does the Australian government actually have over that information, so on and so forth,
Well, that's right, and there's those dimensions, but there's also the proprietary dimensions with regard to the actual facility and also with regard to the information itself. But one aspect that's forgotten is that, the hype and the nomenclature is, the cloud, everything's in the cloud. Well, it's a myth. The cloud is actually a set of machines that store data that are actually located physically on land somewhere. And then there's a whole number of consequences of that in terms of rights and obligations in the usual way. It's just that the people that are facilitating all this don't really want you to think about that too much. But we need to. So that's another dimension of that. Anyway, it's 10 to 9, folks. I think we might call it a day. If everyone's happy to call it a day at that stage. I'm a bit tired, I reckon. So hopefully that was useful, provide a bit of guidance. Remember those points with regard to the assignment that's upcoming. Remember that you've got until 11:45 p.m. on coming Monday, the 16th, to submit your assessment. All students have that benefit of that extension without penalty. Stay within the word parameters. And if you haven't yet done question 1 and you're thinking about doing it as a multimedia presentation, either a vidcast or a podcast, be encouraged. Be encouraged to be creative, be encouraged to use the technology, and it makes it more interesting from my side of the table, but it also gives you a chance to think about how you present things through the lens of technology. So there we are, folks. It's good night from me and it's good night from him.
Good night.
Good night.
Night. Thank you.
See you. Bye.